First off, Section 37. It states that any confession caused by inducement, threat, or promise is irrelevant in a criminal proceeding. Why? Because the reliability of such confessions is seriously compromised. Imagine a scenario where an accused is promised leniency in exchange for a confession. The fear or hope induced could easily lead to a coerced statement, lacking any genuine admission of guilt. Next, let's talk about Section 38. This section makes it clear that a confession made to a police officer cannot be used as evidence in court. The rationale here is to prevent abuse of power and ensure that any confession presented as evidence is made voluntarily and without undue influence. It's a safeguard against potential misconduct and aims to uphold the integrity of the legal process. Moving on to Section 39. This section goes a step further by stating that any confession made while the accused is in police custody is also inadmissible against them. Custody creates an environment where the accused might feel pressured or intimidated, which could lead to false confessions. The law recognizes this risk and seeks to protect the rights of the accused by excluding such confessions. Section 40 adds another layer to this protection. It specifies that only information received from the accused, which distinctly relates to the facts of the case and is discovered in consequence of such information, can be proved. This means that if the accused reveals something that leads to the discovery of new evidence, that specific piece of information can be admitted. However, the confession itself remains off-limits unless it meets the strict criteria set by this section. Lastly, Section 41 addresses situations where a confession is made after the influence of inducement, threat, or promise has been removed. If it can be shown that the impression caused by such factors has been completely erased, then the confession may be admissible.